Hello, my name is Brian Mayer. I am an attorney practicing family law in Southern California, and today I'm going to be answering the important question of in what state does one file for custody of their child. Now, when I finish with this video, you are going to be an expert on the subject. You are not going to have any doubt about where you should file for custody of your child. So if you find that this information is helpful, please consider liking the video and subscribing to my channel. I post videos like this from time to time, and subscribing will allow you to see those videos, and if this one's helpful, those will probably be helpful to you as well. Now, to understand the answer to this question, the first thing that we have to talk about is something called the Uniform Child Custody Jurisdiction Enforcement Act, UCCJEA. Now, you will hear this again and again throughout your process, so write that down. The UCCJEA is a set of laws that the states came up with that they could all agree to so that there would not be any fighting over who should hear the case, who has jurisdiction. It used to be in the old days that you might have a parent who lives in California and they split up with their significant other and they move across country to Florida and they immediately file for custody. And then the Florida courts and the California courts get into a fight over who should settle the question of custody. Sometimes both states wanted to make the decision, sometimes neither state wanted to make the decision, and the UCCJEA resolved this. Currently, as of March 6, 2020, 49 states, the District of Columbia, Guam, and the Virgin Islands all have passed the UCCJEA. The lone standouts are Puerto Rico and Massachusetts, but even then, as it pertains to this question, they're in agreement. So all 50 states and all of our territories, the law is exactly the same. And the way the UCCJEA works is that it decides the question of jurisdiction, original jurisdiction over custody of the child based on the home state of the child. Now, what is the home state of the child? The UCCJEA says that a child's home state is where they have resided for the 6 months, where they have resided with at least one parent for the 6 months prior to filing for custody, okay? So what that means is if, for example, mom and dad are living in California and mom takes their child and moves to Idaho with him or her, once 6 months have passed, she can file for custody in the state of Idaho. She doesn't have to do it back in California. But what that also means is that if a child has been moved out of their state and less than 6 months have passed, then jurisdiction may go back to that original state. So let's say that you have a child who's 10 years old and they've lived in California all of their life, and mom takes the child, moves them to Idaho. 3 months later, dad files for custody back in California. Both the California and the Idaho courts will generally recognize California still as the home state for the child. So where the child's home state is depends very much on where they've lived and how long they've lived there. If a child has lived in a state for 6 consecutive months and nothing else has been filed for custody anywhere else, that is their home state, where they reside with that one parent. Now this, of course, next raises the question of what happens if the child has moves to a new state and they've been there for less than 6 months, but their last state, they did not live there for 6 consecutive months either. Where's the child's home state? Well, when you have a child who's moving around between states a lot and they've not been in their current state for 6 consecutive months, they weren't in their last state for 6 consecutive months, and more than 6 months have passed since they were in a state for at least 6 months, then custody is decided by the court that in the state where the child has significant connection. Okay, so what is significant connection? Well, that's a little bit squishy, but I can say for certain if you have a situation where the child has lots of family in the state, if they've been enrolled in school in the state and they have friends in that state, if they have ties to the community in that state, if they were on sports team in that state. If all those things come together, it will be really easy to make that decision of where does the child have significant connections, even if they've been in that state for less than 6 months. So now let's say that mom and dad have lived with their child in California for 4 months, and then they all move to Florida for 4 months, and then they all move to Idaho for 4 months. And then mom takes the child and she moves the child off to Alaska. And a week later, she files for custody in Alaska. Since none of the states involved a situation, since more than 6 months have passed, since the child lived in a state for at least 6 months, since the child has not lived in the current state for 6 months, the home state will be where the child has the most significant connections. It might be Idaho, it might be Florida. It's probably not going to be Alaska because mom was only there with the child for 1 week in Alaska. So at that point, you're going to have to look at all of those factors. Now, this also raises the question of what happens when you're dealing with a child who's less than 6 months old. Let's say you have parents who live in California and they have a newborn child and the child is 3 months old, and then the parents split up and mom moves to Idaho and she's there for 2 or 3 months and she files for custody in Idaho. Where is the home state? Well, there's not been 6 months that have passed, so it's going to come back to significant connections. Does the child have more significant connection in Idaho or in California? In that situation, the child has been in both states for about equal time, so the Idaho court will probably recognize jurisdiction and hear the case simply because it's a little bit more recent relative to this child's young age and short life. Also, if a child is simply under 6 months old and has lived in their current state for less than 6 months because they've been alive for less than 6 months, that will also be their home state. Now, there's one other possibility here, and that is what happens when the child simply has no significant connection to any state. Let's say the child lives with some gypsy parents, and the parents move from state to state. They're in California 1 week, they're in Arizona the next week, they're in New Mexico the next week. They just move around a lot, or maybe it's just the case that you've moved between a few different states in the last 6 months, and the child simply has not had a chance to develop significant connections to any of those states. Then what basically happens is the courts will look at just where it makes the most sense, where the most substantial rationale is to have the child, and that still kind of ties into the significant connection, but it's a lot less weight than that significant substantial connection standard. So the first thing that they will look at is where's the child lived for the last at least 6 months, within the last 6 months. Next question is that substantial connection, and the third is if none of those are met, then just where does it make the most sense? And so that's how the decision is made where to file for custody. I hope that you found this helpful. Please like and subscribe the video. Let me know with any comments if you have any questions. Take care and good luck.